If they can do this to one of the most well-documented tribes in America, they can do this to any tribe.
The Mashpee Wampanoag Tribe's court hearing in the Department of Interior's suit, scheduled for May 7th, has been pushed to May 20th at the Washington, D.C. courts. This suit against the department was filed in September of 2018, when the department released their determination that the tribe did not fall under federal jurisdiction in 1934. The 2016 judgment on the Littlefields case brought the tribe back to the Department of Interior to prove federal jurisdiction in 1934, as suggested by federal Judge Young. Both parties were able to argue in response to each other's submissions. Everything that was submitted by the tribe was based off of the solicitor's M opinion from the Department of Interior, 37029. That determined how a tribe can prove they were considered under federal jurisdiction in 1934. This was enacted in 2014 under the Obama administration in response to the Carcieri Supreme Court ruling, which stated that any tribes that were not under federal jurisdiction in 1934 can have land held into trust. It was developed before the Obama administration released the tribe's original record of decision in 2015 that stated that the Department of Interior didn't need to determine if the tribe was under federal jurisdiction anyway. A few weeks before the Department of Interior ordered they were disestablishing Mashpee's reservation lands, the Solicitor's Office of the Department of Interior signed the withdrawal of that opinion that gave the meaning of under federal jurisdiction. The same M opinion that the current administration used to determine that the Mashpee Wampanoag tribe did not qualify as being under federal jurisdiction in 1934. U.S. District Senior Judge Paul Friedman, who's overseeing this case, said he was disturbed to have discovered the withdrawal of the solicitor's opinion on his own. The government failed to bring the withdrawal of the M opinion when it released it in early March, and throughout the months this case has been actively developing. This hearing is on the tribe's emergency motion filed for a preliminary injunction and temporary restraining order against the Department of Interior to halt the disestablishment of the reservation lands. The hearing was moved from May 7th to May 20th when the Department of Interior failed to notify the courts of the withdrawal of the M opinion, so the judge is giving both parties more time to brief the issue and answer his questions. They'll give 75 minutes each for arguments via teleconference. The 400-year history of federal jurisdiction of the Mashpee Wampanoag tribe will be displayed throughout this case. The Department of Interior's hold on disestablishing the tribe's trust lands was extended until June 5th. Many tribal citizens and supporters lit fires this past Sunday to take part in a worldwide prayer protest for the Mashpee Wampanoag tribe to keep the trust status over the 321-acre reservation lands. Those who support this cause, including Mashpee TV, are hoping that the prayer protests will help positively affect those decision makers that hold the tribe's fate of the land in their hands. The public can listen to the oral arguments of this hearing Thursday, May 20th. Follow Mashpee TV on Facebook and Twitter to get the teleconference information and time when we get closer to the day.
Hey, hey.